Well, the first stage is investigation and evaluation. And that's where an attorney, when brought into a claim, will, let's just use a motor vehicle accident situation. The attorney will get the officer's crash report that will have the details of what happened. The attorney would then get photographs from the scene or body camera from the investigating officer, just to investigate, okay, what happened during this motor vehicle accident and what do we need to do to prove a case on behalf of the family of the person who was killed. The next step, if there is a claim to be made, would be to file a lawsuit. And that's simply a matter of going down to the county courthouse where the accident happened, filing a written document called a complaint. In that situation, once that happens, the defendant, which would be the responsible party that's being sued by the estate of the person who was killed, would hire an attorney, and that attorney would appear. The next stage of the case would be what we call discovery. And really two types of discovery. There is paper discovery, that is sharing of documents, sharing of information in response to written questions called interrogatories. And then there is something called depositions. I bet lots of people have heard about that. You sort of see that on TV and movies sometimes. And that's just a matter of going to an attorney's office and taking a deposition of either the people involved in the motor vehicle accident, or witnesses, or police officers, or medical doctors involved in care, and asking questions about what happened. All of that is towards developing evidence to prove liability, that is, who's responsible for the accident, and damages or injuries. That is, what is the effect of the death of this person on the survivors and his or her family. The next step is what I would describe as negotiation or mediation. And that's after the evidence has been brought in and evaluated by both the attorney for the estate and also the attorneys and the insurance companies for the responsible parties. There is typically an opportunity to try to settle the case, either through direct negotiation, just attorneys and insurance representatives talking about dollar values and risk in front of a jury and trying to get a case settled. In the last 20 years, a process known as mediation has sort of sprung up, and that is a little more formal negotiation where attorneys and insurance representatives and representatives of the estate of the person who was killed will actually go to a third-party attorney called a mediator and try to negotiate the case through the mediator. If the case isn't settled, the final stage of a wrongful death lawsuit would be a trial. And that is usually something that would happen 18 months or 2 years after the filing of a lawsuit, after all the evidence is taken in, evaluated, and the case has not settled. And then you take the case to a jury in that county, and 6 people who you don't know and the defendant doesn't know gets to decide what to do with the case based on the evidence and the argument presented by the attorneys.